Good afternoon, everybody. My name is Andrew Zwerling. I'm here with my partner, Marianne Monroy of the firm Garfunkel PC, and it's our privilege and pleasure to conduct today's presentation, conducting employment-related internal investigations. For those of you who have attended webinars that Marianne and I have conducted previously, you can sip your coffee for a moment or so as I go over briefly the background of our firm, of Marianne and myself, because those of you who have attended have heard this many occasions. As far as Garfunkel Wild is concerned, we're a full-service healthcare law firm with around 90 attorneys in New York, New Jersey, Connecticut, Florida, and Washington, D.C. We've been around now for almost 44 years. By full service, I mean healthcare, litigation, employment, corporate, managed care, compliance, finance, etc. And we have since branched out well beyond the healthcare industry as well. Marianne and I have decades of experience as litigation and employment attorneys. We've handled matters from the local trial level through the United States Supreme Court, and we wear two hats. Marianne is the chairperson of our employment law practice group. I'm the chairperson of our litigation practice group, and both Marianne and I, on a day-to-day, if not regular basis, put out fires with regard to employment counseling, conducting internal investigations, sometimes of magnitude involving dozens of witnesses. But we also litigate, and we see how matters evolve and how they're handled well or poorly by a client. We see it most vividly when we do litigate cases and have to prepare to defend the litigation, if not go to trial. We also have given presentations of this type in person, remotely as well, with crowds numbering the hundreds. But with Marianne and myself, we follow the same protocol. We truly welcome questions throughout. You have the chat feature on the bottom of your screen. We'll do our best to answer your questions as the presentation goes on. And if not, we can always catch up with you after the presentation. Additionally, this course is offering CLE credit in New York, so I'm required, consistent with CLE protocols, to read the following. The content of the course is acceptable for both newly admitted and experienced attorneys. Please be sure you stay connected on Zoom until the program concludes at approximately 1 o'clock. This webinar is approved in New York for newly admitted and experienced attorneys for 1 credit in professional practice. For New York CLE attendance verification purposes, all course codes, and there'll be one at the end, announced during the program must be recorded on the attorney affirmation and evaluation forms and emailed to Ivan Rodriguez of our firm. If you have any explanations or questions during the program, as I mentioned, just use that chat box on the bottom of the screen. In that same chat box, you're going to find a link to the evaluation and CLE forms. So with regard to the subject matter, internal workplace investigations are often necessary to discover, address, and prevent workplace problems. And in our presentation today, we're going to cover some of the key considerations and appropriate procedures for conducting investigations of this type. We're going to address the benefits of conducting internal workplace investigations, which situations warrant an investigation, what are the risks associated with conducting these investigations, critically, what are best practices for conducting them, and finally, some post-investigation tasks and considerations.
All right, good afternoon, everyone. Happy to be here today, and I took a quick look at the registration list, and I think Andrew and I have worked with many of you in the past. Some of you I've actually dealt with investigations in the past, so we've gone through this exercise before, so I'm looking forward to doing this again. Let me move on to the first slide here. Let's see if I can get the mouse to work here. There we go. All right, see, we're a good team. All right, so the first thing we want to start off, so why do you conduct an internal workplace investigation, right? So as managers, leaders of your organization, many of you regularly receive complaints, right? And they can range from the things that we know we really need to address: discrimination, harassment, health and safety, workplace violence, violations of your rules, your protocols, theft, fraud, criminal activity, right? It runs the gamut. But you'll also receive complaints, and I'm sure some of you have heard this, like my coworker plays their music too loud, they get better shifts, I don't like this, the food isn't great in the cafeteria. It could be anything. The microwave, we've gotten complaints with the microwave being heated, the food in the microwave smells, it's causing me a headache, right? There are all kinds of types of complaints that you have to investigate. Some require a more comprehensive process, others you just need to make sure that you address it and not let things escalate. All right, so internal investigations, they're a tool for a variety of reasons, okay? So one, you have to deal with the actual incident at hand, right? So let's say it's workplace violence, right? You got to deal with the actual issue, and consider, do the allegations have merit? Who is involved? What kind of disciplinary measures do you have to take? How do you stop a reoccurrence of the particular incident if you determined it happened? And other preventative steps and measures to protect the work environment. So secondly, you want to do an investigation also to make sure you have a positive work environment, because if employees see you do an investigation when they have complaints, they know you're listening to them. So what does that do? It makes morale go up, it increases productivity, reduces turnover, right? And it creates a culture at your particular work site, right? That people who are engaging in inappropriate behavior, harassing behavior, it's not going to be tolerated. And thirdly, an internal investigation also will limit your potential liability and serve as a defense tool for potential claims down the road, right? So one of the defenses you may have as an employer in the event of some type of inappropriate or harassing conduct is that you took prompt action, that you took the complaint seriously, okay? And even if that defense doesn't work in all jurisdictions, it could help mitigate your damages to show that as soon as we learned about this problem, we quickly acted upon it, okay? The other thing I want to be careful about too is if you're going to do an investigation, certainly one where the allegations are pretty serious, you got to make sure you also do it thoroughly, because I've had complaints and lawsuits, we've had complaints and lawsuits where the plaintiff or the complainant is saying, well, that was just a sham investigation. They asked a few questions, dismissed it. They just wanted to keep so-and-so in the particular position. So it is important that you cross your T's and dot your I's, because it actually can undermine, be worse if you do a sloppy or poor investigation. Okay, let's see if I can get the next slide on my own here. Yep. All right, so types of investigation or workplace issues that definitely warrant an investigation. As I said before, so violations of anti-discrimination statutes. So if somebody is saying I'm being mistreated or unfairly targeted or harassed because of my age, disability, gender, any of the protected categories, right? Those are things that are going to warrant investigation. Even if you think they lack merit, right? You still need to address them, okay? And hopefully you have an HR person or someone who's knowledgeable with red flagging, right? These issues that require investigation. Okay. Next, you want to make sure you look into issues or violations or purported violations of workplace health and safety statutes, okay? So things that will be implicated is workers' comp, right? Someone gets hurt, injured on the job. You're going to investigate internally, right, to make sure that you're not going to have a problem or reoccurrence, and you address the safety issue, a potential safety issue. But you also need to address it from a workers' compensation standpoint if you have an employee that's injured, and certainly if they're seriously injured, and death could be a possibility too. Even less serious allegations, you still want to address them, and sometimes do, a safety audit. Make sure that your facility, especially if you are in the medical profession, a professional facility, right? You want to make sure you have all your OSHA stuff taken care of, right? Check, are your exits blocked, or are there things in the hallway blocking fire exits, fire extinguishers, people know how to where the OSHA logs are, because those are the types of things you want to make sure you have in place. One caveat there, right? If you do these safety audits, which you should be doing, and you identify a problem, right, you need to fix the problem. You can't identify the problem, document there's a problem, and wait 3 weeks or a month or 6 months later to address the problem. Okay, so that's going to be really critical, especially on the real, pressing safety violations, that you take some immediate action. Okay, workplace violence, obviously another one you need to address immediately. Now, sometimes before you can even do an investigation, you got to suppress the potential threat, okay? So that might be send somebody home, call the police. You got to protect the work environment first before you even can get to the investigation part, right? Protect the work environment. Then you start to put together your plan on how you're going to investigate, and we're going to talk about that a little bit further. Now, for workplace violence issues, even safety issues, hopefully you have some type of either a committee or designated people, and that's for sexual harassment as well, who is going to be the receiver of those complaints, right? Or address and handle those complaints. So if a mid-level manager gets that complaint, it gets escalated to the right individuals, who will then have a protocol in place or a policy in place as to what they are going to do next, okay? And we'll talk a little bit more about calling the police when circumstances warrant, especially things like embezzlement. And, we've had situations where people are propping cell phones to record people in the bathrooms, right? We're calling the police right away. Next, drug and alcohol usage, okay? Those are also things that we routinely get involved with our clients to investigate. There is a nuance there now with recreational marijuana. So that's a whole nother class, but people, that doesn't give you license to smoke while you're on the job. But certainly when you do drug testing, and that raises different issues with drug testing as far as the recreational marijuana standpoint. However, if you have an employee that's operating heavy machinery, equipment, right, you really have to make sure that the work environment and the employee is safe if there is a suspected drug and alcohol usage. And again, the investigation process applies to any one of these particular items, right? So when we go through those questions and how to plan for it, we're just red flagging for you now. You have to address this. Someone tells you, like, look, your neurosurgeon or your orthopedic surgeon, right, is working on somebody, and you think that they have some kind of, they're under the influence. You need to stop the presses, right, and make sure that there's no issue there. Employee theft and fraud, another thing that Andrew and I routinely get involved with. And that doesn't just mean taking money from the cash box. It could be, a more elaborate scheme with taking checks that come in from different payers, or even theft of time, people not clocking in properly, or modifying their clock ins and clock outs. So that's all employee theft. And lastly, another example is violations of the employee rules and code of conduct. This is particularly important when you're doing annual reviews, right? And if you're going to ding an employee because you say, okay, you didn't perform well and you weren't following our policies and procedures, but you never raised it, investigated, had all your facts in order, that can become a potential issue. So you want to make sure that you're looking at those types of things. And sometimes you'll get people reporting to you, so-and-so's not wearing gloves, and they should be in the medical profession, or, they weren't following the 2-person assist order, or whatever it might be. You're going to want to make sure you follow those things. All right, so moving along, and again, if anyone has any questions, feel free to ask.
The two, yes, you'll have access to the slides for reference. I think the recording is going to be on our website as of tomorrow. And the other question was, when should a note to file be used for an employee's record as part of a disciplinary action? We're going to talk about that later, but it's going to be at the back end of any investigation and outcome and conclusions and so on, right, before you would do that.
Yeah, but you're going to record the outcome of any investigation that the employee participated or was part of.
Yep.
All right, potential risks. So, If conducted properly, the investigation is going to help you defend potentially a lawsuit and liability. It's a strong defense to that, as I said before. But there are some potential risks, discovery concerns, right? Internal investigations, in most instances, are discoverable. And sometimes that's really helpful because you're going to want to show, I looked into this, I addressed it, I either found no merit or maybe you did find some merit, but you addressed it, okay? And one of the things you're going to have to consider there from a perspective of confidentiality is who, and Andrew's going to talk about that in a little bit, is it outside counsel and you can cloak it a little bit more with attorney-client privilege, or is it in-house counsel? These are the types of things you're going to think about, but government agencies can often get disclosure of the notes and investigation reports. And we don't always do an investigation report. That's also something to keep in mind. Sometimes we do the investigation, reach out conclusions, but we're not going to do a formal report because we know it may cause more harm than good to have some stuff in writing.
Okay, privacy concerns is another thing you should be thinking about at the onset of an investigation, depending upon the subject matter and the type of evidence you're looking to use during your investigation. And why do we raise that? Well, federal and state laws protect employees' rights, privacy rights in various ways. For example, you have the Federal Wiretap Act, which is designed to protect the privacy, for example, of electronic communications. But it does not prohibit an employer's either interception of or access to electronic communications when it's done to protect the rights or property of the employer. And to be found compliant with the Federal Wiretap Act, the employer, and this is a light lift, just has to demonstrate that the monitoring that you're doing is done for business purposes and that you've given notice to your employees. Well, all of this sounds really obvious, but Marianne and I, we gave a recent webinar presentation on social media issues. And you really need to draw that line as far as gaining access to evidence during an investigation with what might be on the employer system versus what might be on a social media site of your employee. There's a very different set of rules applying to one versus the other, and you need to take that into account, because if you cross that line and encroach on the employee's private communications, you can run afoul not just of the Federal Wiretap Act. New York has new legislation that's kicking in 2024 as well that has certain protections and certain penalties if you violate that particular legislation.
Okay. A few words just about defamation concerns that you have to be mindful of when you're conducting these investigations, particularly when you're dealing with allegations of criminal activity. Okay, so when you accuse somebody of criminal activity, there could be a potential defamation claim if it's untrue, right? So be very mindful of not making conclusions without facts, okay? And when it comes to who stole the purse or who stole the money or whatever it might be, if your results of an investigation are inconclusive, but you're fairly certain, right, that you have some people that maybe you can't trust, or their judgment was poor, or maybe didn't follow protocols, right? I usually will, not usually, I always stay away from the emphatic conclusion, they stole it, they must have stolen it, who else could have stolen it, right? It's better to, in my opinion, to say, look, the allegations did not conclusively support that so-and-so stole the pocketbook. However, circumstances indicate that so-and-so was one of the few individuals that had access. Maybe you put that in, but say regardless, right? You could say that something along the lines, let's say it's the cash box money is missing. So-and-so didn't follow the protocols to safeguard the money, log it in, log it out, and based upon their failure to follow protocols, some trust issues, we're going to take XYZ disciplinary action and maybe the termination, right? So, that's how I would probably go when we're dealing with the theft and criminal activity. The investigation, going back to what we said before, you'll be able to also, as part of the investigation, identify where you have those vulnerable spots that you can then implement fixes so it doesn't happen again?
Retaliation concerns, this is a significant one. Employers need to ensure that no one involved in the investigation and no one at the employer who learns of an employee's participation in the investigation engage in any retaliatory conduct toward either the employee, the complainant, witnesses, and so on. The anti-retaliation provisions in the federal law and state law are pretty broad and are rigidly enforced. Even when the underlying conduct may be fairly minor and innocuous, we've had cases where at the end we said the conduct was vanilla pudding, maybe do some training, and the person that ultimately was terminated, even at the higher levels, because of retaliation issues. So it's something that needs to be imparted to employees on a regular basis. Marianne and I, when we do these witness interviews, with regularity, each witness interview, we stress the anti-retaliation component.
All right, and I'll just say briefly, as far as contract claims, if you are a union outfit and you have to make sure, most of the times the union employees need a delegate, a union representative present, so be mindful of that. The other thing too, if there's a union contract, you may have to follow some pattern of or lockstep disciplinary action. It could be verbal, then written, then suspension. If the alleged conduct is egregious enough, there's usually a caveat that says you can pass directly to, what's the thing in Monopoly? Go directly. You can move to termination if you need to.
Okay, so next up, conducting the investigation step by step. What's first? You need to identify the goal of the investigation, to say to yourself, what are we dealing with? What are the issues to be addressed? What are we taking on? Is it a narrow issue, or is it one that has internally global implications? Once you decide that, then you can craft your investigation plan, and tailor your investigation plan accordingly. Are you dealing with a sexual harassment claim that might involve dozens of witness interviews? Or is this just an employee, a late time clock, punch claim? So, size up what's involved, and the plan will then flow from there. One of the initial things you're going to consider after you identify the goal, who should conduct the investigation? Deciding who should conduct the investigation is a key critical component, because again, depending upon the nature, severity, and scope of the matters being investigated, that question will be answered in a variety of different ways. For example, if you have a robust HR department, a lot of the issues that we're talking about can just be handled internally. You don't have to do the reach out to people like Marianne and me. But again, it depends upon the specific issue. What are some of the issues that you should consider in assessing who should conduct the investigation? Should you have an internal or a third-party investigator? And you can go back and forth on those. Internal, depending upon the magnitude, it might be more prudent and cost-effective to do it. But also, depending upon the internal issue, you might want to bring a third-party investigator in to lend a certain weight to the investigation and to impart to the employees how serious you're taking it, that you're reaching outside for further support. The other issue is, do you use an attorney or a non-attorney investigator? You as an employer should also consider whether or not you should involve law enforcement authorities in the investigation. Marianne spoke about workplace violence issues. You should also decide the extent to which HR should be involved, and we'll talk about that a little bit more momentarily. Even if HR is not conducting the investigation, how much should HR still be involved? Regardless of who conducts the investigation, and it should go without saying, but they should have certain qualities. One, they have to have expertise and experience in conducting investigations. Marianne and I, as Marianne mentioned before, we followed up and have been brought in to clean up some flawed investigations, or we've dealt with them in litigations when it's too late. So you want to have people skilled in how to conduct a proper investigation. You want people, again, these things seem obvious, but if they were so obvious, people like Marianne and I would be a whole lot less busy, who are unbiased. If you don't want no one named in the complaint as part of the investigation. You don't want anybody in the chain of command involved in the investigation. You don't want anybody who may be a witness involved in the investigation. You want the investigator to be knowledgeable about federal and state employment laws and what constraints that may exist in terms of what questions you can ask, how to ask questions, what the parameters are. You want someone committed to upholding the privacy rights of employees in the workplace. We had one that stands out a short while ago, a sexual harassment claim. We get there and we start asking people in the normal course, do you know why we're here? And each one said, sure, you're here to investigate the sexual harassment claim of so-and-so. And we said, well, how did you know? And it turned out that their chief compliance officer was some chatty individual who just couldn't help, fueling the gossip mill. You want someone who's going to be discreet, recognize the need for confidentiality. You want someone who's dedicated to achieving the goals of the investigations. Also, the decision on who you use may also impact whether the investigation is protected by the attorney-client privilege or work product doctrine, which we'll talk about again later.
Okay. All right. We on the next slide? No, we're still here. Okay, so should law enforcement be involved? And that is really a fact-specific inquiry, okay? So there are certain things, as I said before, it's a no-brainer. You're going to call the police when, people are propping up cell phones in bathrooms and grabbing someone, or we've had on more than one occasion, for whatever reason, the employee's spouse or significant other is coming over to the workplace to beat up somebody who, they think was speaking poorly or did something to their significant other, and we're going to call the police, okay? But then there are other things that you got to think about, right? Depending on the situation. Some of the assessment is, okay, do I have a legal obligation to report things? And whether it's the police authorities, OPMC, data banks, there are, from a medical standpoint, certain reporting obligations, right? Criminal conduct involving children, child pornography, right? You might have to, you will need to report those kinds of things. And then other things you're going to think about, depending on the nature, severity of the action or the incident. Some assessment or consideration may be, okay, who's going to be affected? The accused person's, families are going to be affected. What about the remainder of the workplace? What's that person's history with the organization over time? Again, it's a full picture type of view. Potential defamation claims. If you report something, say something, and then it's not correct. Negative media attention. Okay. And that stuff, then, even if you report this, you may have to deal with, and you have to be prepared for that. The news reporter might be outside your front door. Potential lawsuits. You may want to report it too, because cooperation with law enforcement, if there was a real issue there, it might bode well if you were cooperating with law enforcement. I mean, we have a whole department in our office with white collar claims that you really have to think about how you go about doing that. And when you report something to law enforcement, they're going to ask for your records too. So you got to be mindful that you may be turning over a lot of your investigation materials, as well as plenty of other business records. So it's something you want to think about all around before you make that call. Then, as Andrew was saying too, choosing the investigator, whether it's internal or third party, right? Advantages of the internal person, right? They're familiar with the organization. They know the players, they know the people, right? They know how to approach somebody, right? They know the person that's going to fly off the handle when you try to interview them, and they're going to know how to approach that person best. They can probably get started with the investigation more quickly because they have more background information. And if you're doing it internally, presumably you have a process, and that person can keep that process very consistent, as opposed to bringing someone out from the outside. Credibility with the employees, right? So if you have a trusted HR person, employees may feel comfortable speaking to that individual rather than an outsider. And cost effectiveness, right? You don't have to pay someone from the outside to come in. So in contrast, right, you have someone from the outside come in. There are some people that are going to say, you know what, that person's not biased. They don't have favorites. They're objective. again, it really depends on who you have internally that can conduct that investigation, and an outsider may be better, particularly if you're investigating, let's say, a high-level employee, or you think you're going to have to terminate somebody at a high level, right? You might want to have the outsider come in to do that. And I think that some other disadvantages, let's say, of using an external, investigator, it's the investment of time. It's going to cause them, require them more time to start up. And I think that's about it when you choose between internal investigators.
Attorney versus non-attorney investigator. The advantage of an attorney investigator, it allows the employer to apply the attorney-client privilege to the investigation in many, but not all situations, because the attorney-client privilege in this context is not absolute. For example, where an in-house attorney plays a business and a legal role, the privilege generally may not apply if a court finds the attorney to have been conducting the investigation primarily for a business purpose rather than the attorney's legal role. However, the flip side of that is the privilege generally will apply if that lawyer is providing or seeking legal advice as one of the significant purposes of the investigation, even if there is an overlap with some underlying business purpose. If an attorney is conducting the investigation, that attorney should provide the employees with what's called an upjohn warning, explaining that the attorney represents the employer, not the employee. And in doing so, the attorney should make it plain in totally clear language to that witness that the attorney-client privilege applies to communications between the employer's attorney and employees, and that privilege belongs to the company, and it's up to the company or employer to choose whether or not to waive that privilege and disclose what the employee said. But let's say that you have an appointed investigator and it's not going to be HR. Should HR still be involved? In most cases, and that's the view of Marianne and my view as well, the HR should still be involved in the planning and execution of an investigation. In the effort to preserve the attorney-client privilege, when HR conducts any witness interviews without the involvement of the counsel, however, HR should indicate in all interview notes and other documents that a significant purpose of the investigation is to seek legal advice, or that the interview is being conducted at the direction of counsel for the purpose of seeking or providing legal advice. Again, it's not a fail-safe, it's no guarantee that's not going to be discoverable. I'm not suggesting that, but you want to heighten the possibility of it being precluded from discovery. In addition, all witnesses and participants in the investigation should be informed of the investigation's purpose. Regardless of whether HR is involved in the investigation itself, it needs to be involved in assuming you found misconduct, and that discipline should be the issue of whether or not discipline should be imposed is now in front of you. You need HR's input, because HR is, as it should be, is typically going to be the entity or group that is the repository of all disciplinary information. And a key element in handling employment matters in any organization is consistency. And you don't want to act in a singular fashion on the case before you. HR is going to know, here's how we handle that situation in other instances. So you have consistent treatment, and that'll help also minimize the possibility of some discrimination claim arising from a wrongful outcome or a wrongful discipline being imposed. As far as HR's involvement, again, it should be obvious. We've had investigations, we've had litigations, again, the too late point where HR was the target. Some wrongdoing alleged in the HR department itself. Obviously, HR can't be involved in the investigation under those circumstances.
Just a quick note, let's say you're a smaller practice, okay, or a smaller entity, smaller employer, and you don't have an official HR. So we're using that term symbolically. So it's the person who handles those type of employee complaints, right? So it could be a compliance officer, it could be a practice administrator, it could be the office manager, right? It's the designated person who, Andrew said, will provide the consistency, follow the protocol, okay? If any of you were wondering, what do? I don't have an HR department, okay? It's okay. All right, so next thing is planning the investigation. Okay, this is a mandatory step. I don't want to overstate it, but overstate that it has to take forever to do the planning part, but it's like trying to write a brief or trying to write a report without having some semblance of an outline. Okay, so we're going to do that here. I'm going to just talk briefly, right? We're going to talk about, okay, when do we start the investigation? It sounds simple enough, right? But, certain things, you got to start them right away. There's threatened violence, right? Stuff like that. You're going to make the workplace safe, and you got to make sure this isn't going to happen again and step in right away. There are other things that you may going to take a little bit more time. It could be some type of theft or embezzlement type of thing. Maybe there's surveillance cameras you got to first look at or consider. So there's going to be that. There could be vacation schedules that you need to deal with too. So there's going to be some consideration about that. Next, do you transfer the employee who is accused of the wrongdoing? Do you transfer them pending completion of the investigation? Do you suspend them, right? And that's with or without pay. I usually, when people tell me with pay, I'm like, okay, we're putting them on vacation. So I'll usually say non-suspension without pay, retro it back if you find that there was no wrongdoing. Okay. Now, you can't always suspend the accused person, right? So if you're dealing with nurses and there's a shortage, right, you may not be able to give up a nurse, right? But you might be able to transfer the nurse who's accused to a different floor if we're dealing with a hospital. Or if it's a doctor that's being accused, but they have 10 surgeries booked and we can't impact patient quality of care. So these are the different things you're going to consider. I said before, whether or not it's paid leave, for the accused, but also maybe it's the complainant who was, suffered some kind of injury or threat or whatever it might be, and they're rattled. Maybe you offer them some paid time off, go home for the rest of the day, take it easy, right? That's something we'll offer them, aligned to the EAP, Employee Assistance Program, if you think they need some mental health services on account of some traumatic event that happened in the office, okay? And then the other thing you should keep in mind is reporting lines, right? So if that person who is the complainant is in the same reporting line as the person who they've accused of some inappropriate conduct or whatever it might be, do you have to at least temporarily change the reporting line so that you minimize the conduct and potential, escalation of the claim? So again, things that you're going to need to think about from the get-go.
And just to add to what Marianne said, we're just giving you ideas on what you can do. It's not a one size fits all. You really want to tailor it to your specific situation. Again, you have clients of ours go from healthcare systems involving thousands of employees to small businesses, small practices involving just a handful. So it's, again, not a one size fits all. Importantly, in tapping into any of these possibilities that Marianne described, changing reporting lines, giving somebody time off and so on. You want to be very careful, especially when doing that with the complainant, not to come off as retaliatory. Mm-hmm. If a complainant says to you, no, I feel comfortable coming into work, I'm using this as an example, don't say, you know what, for your benefit, I'm sending you home, because that can backfire in a big way with the employee saying, great, I filed a complaint, I told them it's documented, I'm willing to sign something, but they sent me home anyway. That was punitive. So again, we're giving you ideas, tailor it to the specific situation. How should evidence of the wrongdoing, alleged wrongdoing, be treated? Lockdown. What you want to do is identify and preserve and safeguard any key potential evidence, anything that may be relevant, whether it's email communications, other computer data, videotapes, memos, time cards, journals, anything else relevant, anything relevant to the alleged wrongdoing you want to maintain. If you have documents that are shown or that you're given, make copies, make sure they stay around. Who should be interviewed? It might be necessary if you're on your own employees, depending upon what's being alleged, might be non-employees to the extent you have access to them. Anyone with potential knowledge, including former employees. Make a list of who they are, create a bullet point outline of the ground you want to cover with those individuals so you're ready when you walk into that interview. You're about to go into the interview, and we're going to go into detail about how to ask questions, what questions ask. What should you communicate with that witness beforehand? Yeah, there's two schools of thoughts. Some employers will go formal, they'll send a letter to the witness, we're requesting to interview you, maybe give them a little advance notice, not necessarily giving facts about what's being alleged, but enough to have them come in prepared. That's the thinking behind it. If we let them know what we're going to ask them about, they'll come in with information, they'll come in maybe with documentation, allows them time to think about it and recall things. The major disadvantage of that approach is that witness then have time to prepare a version of events that aligns with their own interests. Maybe they want to protect their friend or hurt somebody else, or that may or may not reflect the entire story or the story accurately. It also gives them a chance to refuse, and we'll talk about that as well. Therefore, what we typically recommend is just request a meeting. Have them come in, people like Marianne and I, we'll tell them what it's about. It helps keep the investigation more protected. It minimizes the possibility of leaks, which are typically unhelpful to your investigation. If someone's not prepared, you're going to re-interview them if necessary. So that's not really a problem. As far as the sequence of interviews, who should you interview first, second, third, and so on, you obviously should not want to interview somebody who's a minor bit player in the piece. You want to get as many of the meaty facts up front. We typically, but not necessarily always, will start with the complaining witness, speak with other witnesses, find out all of the substance of the allegation of the accused. So when we ultimately meet with the accused, we're as fully aware of the facts being alleged to give that individual a chance to respond to everything, to avoid a back and forth kind of dynamic. What material should be reviewed beforehand, personnel files, policies and procedures that might be relevant, email communications, the complaint itself, again, know what's being alleged, videotapes, anything and everything that's relevant to that investigation should be reviewed by you, as well as incorporated into your witness outline, so you have a nice flow when you actually conduct the interview itself. Review the information. Beyond the information, we take pride certainly with clients that we've dealt with over a period of time, knowing the people, knowing the players, knowing the culture of the employer. And that's real helpful too. You don't want to just know facts. You want to know, wait, is this witness, how do they interact? Are they best friends? Are they enemies? If you can get a sense of that beforehand, it's not always possible. We know that. That would be helpful too. Has a target been set for the investigation's completion? Try and do that. We've had cases where we're brought in and the investigation should not have been ongoing for months, but was. The employees just thought it was a sham at that point, that, for example, sexual harassment, if it was being taken seriously, it shouldn't take 6 months to investigate with a handful of witnesses. Set a target date. It keeps you on track. It keeps a certain momentum, and that's helpful as well. As far as the investigation being documented, no different than we advise our clients to document workplace issues of whatever type, we do likewise. We carefully document the information we learned during the investigation. We don't record the interview. Some people say, hey, it'll give you a verbatim, of what's being said and so on. We feel that it creates a certain chilling effect. We want people to come into the room and feel comfortable with us. Again, it's hard to feel comfortable talking to a bunch of lawyers when there's an investigation going on. But if you have a recording device, we find it tends to have that chilling effect. And so we do our best. We usually have 2 people in the room, not always, but typically, so we can take copious notes to record as much as possible. Also recognizing the possibility that notes being taken maybe might end up being discoverable. So we're careful about that as well.
Yeah. Okay. And just a note on recording, if you are doing it internally and you're recording it, I'm always nervous about that because what you say during that interview could be under scrutiny if we have to produce that recording. So
two quick questions on the screen. When should someone recuse oneself from the investigation process? If you have any thoughts that you have a conflict or that you cannot remain impartial, I mean, that's the broad answer, then you have to you should and must recuse yourself. The other question, can an employee refuse to participate during an investigation process? We're going to talk about that later. The answer is yes, they can refuse, but there can be consequences to that refusal. But again, we'll dive a little more deeply.
Yeah, and I think there's even a question about what should the individuals being interviewed be told. I mean, my eyesight, the screen is a little hard. Should be told how much information to be given. I believe I talked about that a little bit later, but in reality, it depends on the circumstances, right? So in a harassment complaint, I might only say to the witness I'm being interviewed because I don't have like all the facts, right? And that person who's accused may turn out that they were falsely accused. So if I go around telling everybody that so-and-so is accused of groping X, Y, and Z individual, it can really sully their reputation. Particularly even if they're vindicated at the end. So I may say that, look, you're a witness, or we wanted to interview you. So-and-so has been, there's been a complaint made about so-and-so's conduct or perceived interactions with another staff member. So I wanted to meet with you today to get your observations, your experiences working with so-and-so. But then there's going to be cases where I have to be blunt about it, right? So if that person you're interviewing was identified as a witness to the actual alleged groping, I'm going to say, I'm bringing you in because we understand that you were identified as having witnessed X, Y, and Z, and I need to get your input on that. So it will depend on the circumstance.
And in similar fashion, one case that stands out, sexual harassment case in which the complainant had told about a half a dozen people that she had been that's what she accused the harasser of doing. She told a half a dozen people about it. So when we called in the first of many people, but those 6, to Marianne's point, we weren't going to beat around the bush. Right. Complainant said she told you X. Let's talk about it.
Right, exactly. All right. So I think that actually what was the next thing I was going to talk about actually is what should be told. Have a list of questions generally about the subject matter. And as some of you know, my mantra is who, what, where, and when, and try to keep it in chronological order. So when the employee is telling you so-and-so has been horrific towards me for the last 15 years, and it's been a hostile work environment, start off with, when did you first experience it? Give me, what was it? What happened? When did it happen? Where did it happen? Did you report it? To whom did you report it? What was the result of that? Flush out each incident to the best of your ability. Now, they may go off on tangents, right? And go from 1999 to 2005 and back and forth. You got to stop them, right? And say, look, we're going to get to that, but for the sake of just keeping it organized and making sure I have all the information, let's start from the beginning and we'll move forward, step by step. It's not always doable, but to the extent you can, it'll keep your notes, it'll make for a better report if you have to do one. Keep them on track, keep on bringing them back. Okay, I got it, I made a note, but let's stick to this incident first. And listen to what they are saying. We say this to attorneys who are training for depositions all the time. You have your script, right? Which is great, but you're so busy reading your script about the next question that they may say something that's absolutely going to blow your mind, but you missed it, right? They may say, oh yeah, they accused me of X, Y, and Z, but you know what happened? That what they did last Friday to me at the bar around the corner, they grabbed this and did that, right? You got to wake up for that and then ask the questions relevant to that complaint or that side issue. Then you're going to ask, besides all the who, what, where, and when, one of the things that I run into a lot when people do them internally, everybody said they're rude. Everybody said that this person is condescending, berating, a bull in a china shop, okay? You have any examples? No, we didn't. They just said that. I'd be like, so when someone tells you they're condescending, your next question is, can you give me an example? And maybe they can't, but that's then when you go to credibility and you're making your conclusions. If they can't give you one example, it diminishes the credibility of that complaint, okay? And then some of the things they'll say to you, they've been doing all this stuff, they inappropriate text messages. Oh, you have text messages, stop them there. Let me see them. Are they on your phone? Which phone? The phone you have right now? Take screenshots, do it now. You won't get an opportunity to see them again because they're probably thinking, oh, I should have never said that. If they don't want to give it to you, you can't force it. You can't rip the phone from them. If it's a company phone, you can, request the phone back. But those are the types of things you want to make sure you're doing. I know we're a little bit pressed for time, but I just want to one of the other things I generally do at the end, it depends on, sometimes you know exactly what the complainant wants. They want that person fired out the door. There's no reason to even ask a question. Sometimes it could be miscommunication between two employees, or the way they interact is maybe not so professional, but it's resolvable. You may ask the complainant, what best case scenario, what do you want to see as a result? What would make you feel that your complaint was heard or resolved, or what are you looking for at the end of the day? And I would say it a little bit nicer than that. And some of them will just say, look, I just wanted to be heard. I just want to be asked, my boss or my supervisor to be more courteous and not just shout at me when they want me to do something, right? That's all fixable stuff, right? And then you don't have to worry about your superstar, manager having to terminate them because, look, the employee who's making the accusation just wants a little more peace in the office, and you can fix that, okay? And the same questions that you would do for the complainant and the accused, it's the same questions for the people you're interviewing, right? So, but I'm going to add in there, what have you observed? Did you ever what's your working relationship with the accused? Do you ever witness anything inappropriate? Those types of things I would add to the mix. Avoid conclusory types of statements. I would probably say to the employee accused of sexual harassment, can you describe such and such interaction? Such and such said this happened at the holiday party. Can you tell me from your perspective what happened? Not that, did you sexually harass so-and-so, right? I'm going to ask, what was your view of the facts? I'm not going to say when employee X sexually harassed you, what did you do? Things like that. Try to avoid, not just try, avoid defamatory statements. Don't predict the outcome of the investigation. Don't express agreement or disagreement. Don't escalate by getting emotional or angry or accuse them of being liars, right? Those are the types of things you would want to avoid. And we already spoke about the next thing about how much information to give to the people you're going to talk to. It's going to be fact specific, and that's stuff that Andrew and I are here to help guide you with if needed.
Other factors or variables affecting the investigative interviews. How long should the interviews be? Leave yourself enough time, depending upon the subject matter that witness is going to cover. Do not have them go back to back. Leave yourself some time in between. It's better that they run short than they run long. And witness Smith goes out and sees witness Jones. It can create, and we've seen that happen. We have had to deal with that situation and come in and fix it. If you want to maintain again, the highest level of confidentiality, having people see each other walking in and out of a room isn't the way to do it. In terms of location, obviously it depends on the investigator, if it's in-house or not. Our preference is, when we're called in from the outside, is to conduct them on site, but at a location where it's going to be fairly discreet, where you're not going to have a lot of disruption with people going in and out or looking through the glass window to say, oh, there's so-and-so with a bunch of suits being questioned. I wonder what that's about. In terms of determining what documents to use in the interview, again, you want to prepare whatever documents are relevant to that specific individual, and just match them up in your outline so you have a certain chronology to your interview flow where you're introducing those documents, as they relate to specific questions. It avoids the interview being disjointed. You'll get more information from that witness if you organize your documents accordingly. Confidentiality is critical. We keep stressing that point. People are less likely to come forward in the future if they feel that confidentiality is not taken seriously and maintained to the extent practicable, because you can't guarantee total confidentiality. Obviously, if I'm using sexual harassment today for whatever reason, there's a sexual harassment claim, and the complainant told two other people, and now you're talking to them. Now you have three people who know about the interviews. Then you're going to have the harasser. And you can't prevent people from talking. You can admonish them or ask them to the extent possible to keep what you discuss confidentiality, but you can't fully promise it to all interviewees. As some information, and again, it's fact specific about the allegations, and those involved must be disclosed to certain witnesses in order to find out what really went on. And again, let the people know that the expectation level, setting it in the right place, is critical when it comes to confidentiality.
Yeah, and the other thing I just want to mention when it comes to using documents, a lot of times, the complaint will be a written complaint, whether it's an email or the complaint form you have on file that employees fill out. I typically don't share that with people. I may read it, like the accused has the right to know what they're being accused of, so I will generally read it, but for purposes of confidentiality, I don't like things floating about. I don't say I never share it, but be careful that you don't have these documents out there, people copy them and put them on the internet and whatnot. All right, and conducting the interviews, and I know we only have a few more minutes, so I'll keep it short. Yeah, we did. I mean, and I think one of the things, just from the introductory standpoint, just make sure it's clear that you're the fact finder and that you don't represent, and I think, Andrew, you said that before, you don't represent the witnesses or the accused or the complainant, and that you're just there to get the information. Okay.
Anticipating the unexpected, a couple of things. What if, and that was the question raised earlier, the employee refuses to participate? Mm-hmm. You're going to have that. We've had that happen. But fortunately, the law says that you can compel an employee to participate in an investigation. And we're not talking about a union context and a CBA context. And if the employee refuses, you may discipline them up to and including discharge if they refuse to participate. So, that's something that, can happen. Doesn't happen a lot, but it does happen from time to time. What if the employee wants to record the interview? Some people say, I want to record it for whatever reason. The request should be rejected. It can have a chilling effect, but it's even more problematic because now all of a sudden they're going to have a recording that you no longer control, and you don't know what's going to be done with that. They don't have a right to record it. So keep that in mind. What if the employee wants to bring a friend? Again, maybe for their comfort level and so on. Regardless, again, your goal is confidentiality. You want to keep the investigation as discreet as possible in fairness to everyone involved. There might be sensitive information disclosed. And again, we're not talking about a union context or anything like that. Our recommendation is don't allow it. What if the employee wants to bring an attorney? Well, that answer is going to depend upon whether or not the investigator for the employer is an attorney, and whether or not the person to be interviewed is merely a witness or a target / accused. Those are going to be, dispositive variables.
You know what? We should tell you the CLE code before we move on. Its CLE code is 01C as in Charlie, 9, E as in Edward, I as in investigation. There we go.
Well, we have a couple of more minutes for those of you who want to stay on. We're going to walk through the material, I'll put it that way. Post-interview activities.
Okay. So, but before that, I just want to answer one question, which should be really quick. When interviewing, is it required to have them write down their version of events? I have some clients that are insistent, right, that you have to have the person, whether it's the complainant or the witness, write it down, right? I'm not usually such a big fan of that. If I'm doing the investigation, I'm going to get all the information. When you tell people write stuff down, especially whether it's the complainant or the interviewee, you're going to wind up with a journal book, and you're going to have to sift through every one of those things. I find it to be less helpful than me having to, control and direct the interview. Someone's asking for the CLE code again. Sure, no problem. It's 01. C as in Charlie, 9, E as in Edward, I as in investigation. Okay. So 01C9EI, okay? All right, post-interview activities, you're going to organize the information you collected, the documentation you collected, and then you're going to make an assessment. Do I have to re-interview anybody? Is there anything else that I needed? Then make your credibility determinations, right? Were some of your witnesses, seem to lack truthfulness? Were they giving conflicting stories? Were they changing, were there other witnesses that were saying contradictory comments? Did they seem nervous, insincere, changing their presentation, getting red in the face, right? There are a lot of things you're going to look at to determine credibility. Past problems in the past, do they have a motive to throw somebody under the bus? And that's sometimes things that we take into account, right? That their supervisor, who's written them up 3 times, now they all of a sudden want to say they're engaging in a hostile work environment, and maybe there's truth to it, right? I go into it very unbiased. All right. So that's the credibility, and then you're doing factual determinations?
Yeah, depending upon the nature of the assignment given to the investigative report should focus primarily on factual findings and determinations. The investigator should report the facts, let the employer draw the appropriate legal conclusions. And again, that depends on who's doing the investigation and what the assignment has been given to the particular investigation. The conclusion may be different. By way of example, when the investigator is an attorney, because typically under those circumstances, the employees expect the attorney investigator to draw, and we've done that 100 times, draw legal conclusions and make recommendations for corrective action. In terms of drafting the report, it's helpful, not one for optics reasons. It shows how seriously you took the investigation and how well you responded. The report should contain, just in terms of its basic framework, what was the issue that led to the investigation, that prompted it? Who were the witnesses interviewed, and a summary of the information that was gleaned from each one of those witnesses. What was the relevant evidence beyond just the witness interviews that was reviewed, and a summary of each piece of evidence if applicable. Any known evidence not reviewed and why. Maybe a witness refused to come in and participate. Maybe some evidence wasn't preserved. We've had many cases where people deleted texts from their phones thinking that it would made it, those texts unobtainable, when that's not necessarily true. In any given instance. The report, to what Marianne said before, should also contain an assessment of credibility as to each witness and piece of evidence, explain the predicate, like why did you find someone credible or not credible, state your findings of fact and legal conclusions, depending again on the identity of the investigator. If it's lawyers, we include that in our report. And it also depends again on the expectation of the employer, which up front before you commence the investigation.
Right, and not everything requires a full-blown report or a report. It could just be document that you looked in it. So-and-so was, not clocking in and out as they were supposed to, violating the protocols. That's going to be a quick memo to a file. So, and there are certain things, like we said before, for discovery purposes, I might not want a full-fledged report. So you'll give some consideration, and it should be a summary, not a 50-page book. And at the end, if you're going to take disciplinary action, let's say a termination, the summary should support that. So I have sometimes I get the client report, they say, take a look at it. It's one thing or the other. I'll say, well, that certainly sounds like you should be walking them out the door right now, but yet you said you're just going to monitor. So make sure it flows, okay? When the allegations are corroborated, you're going to have at your disposal the various, disciplinary actions that hopefully you have a handbook that are at your disposal, oral, written warnings, last chance warnings, suspensions, terminations. Sometimes it affects people compensation-wise, year-end bonuses. And you want to be consistent, because we've had disparate treatment claims where, one person does the same exact conduct, they get a slap on the wrist, another person does it, different race, ethnicity, age, and they're shown the door. So you want to be consistent on how you deal with the events.
And if the allegations are disproven, well, you need to let the complainant know that, but you really need to stress and then document that you did so to the complainant, that there's no issue of retaliation, they did nothing wrong, they perceive there to be some wrongdoing, they made a complaint, which is what your policies and handbooks authorize them to do. There's going to be no fallout stemming from that. And again, that's absent, and it's been rare when we've had that, some bad faith, false complaint being filed. But again, put that thought on a shelf and don't really consider it for the most part, because you really want to keep it pristine so that employee who filed the complaint doesn't walk out thinking that the guillotine is about to fall based upon the finding that the allegations are disproven or unfounded.
All right, so, and then if they're inconclusive, that doesn't mean you don't take some form of action, right? So 9 times out of 10, employee allegations, it's one employee says something about the other. In many instances, I can't prove it or disprove it. So you're gonna do things like maybe team building, policy, re-education, monitoring, so that you protect the work environment and limit liability for potential claims. And then you want to communicate the outcome of the investigation both to the complainant and to the accused individual. And you don't want to, let's say you find that the complaint lacked merit or it was inconclusive, you couldn't corroborate it. You don't want to minimize or dissuade people from bringing complaints. You say, look, we thank you for bringing this to our attention. We're going to monitor the situation. We hope that X, Y, and Z will maybe bridge the communication gap. We're going to re-educate. You want to end on a positive note, even if at the end of the day, you don't give merit to the particular complainant. I think that's important.
Another takeaway is even in situations where you find that the allegations are unproven or just not founded or can't be substantiated and so on, it's still for any employer, it's still a time for learning and to, get introspective. Okay, this is the allegation. Why did the allegation, even if not founded, take place? What's going on in the workplace? Again, subject to the constraints imposed by anti-retaliation laws, is what can I do as an employer to prevent this from happening again in the future? Do I need to re-examine my policies and procedures? Do I need to strengthen communications with employees? Reevaluate what you can be doing more effectively to prevent this kind of situation from coming to root again. Maybe you need new policies. Maybe you need to come up with, new training or better monitoring or whatever the, outcome may be. But again, use it as a time of reflection to see how you can improve, workplace conditions. That's really about it.
I think that's it. It's been a pleasure. We love giving these type of webinars. I mean, both of us find the employment stuff really exciting. Keeps you awake during the day, sometimes unfortunately at night, but it keeps life interesting. We're here for all of you if you have any questions, concerns, or we could provide any assistance. Again, pleasure. Thank you for having us here today or staying tuned here today. And the materials will be available tomorrow. Okay, so, and if you are an attorney on the line, which I think we have a number of them, joining us, you will get the CLE credit. You just have to fill out the forms.
Have a great day, everybody. Thanks so much.
Thank you.